Good morning, afternoon, or evening, or whenever you're listening to this. You might be listening just before bedtime to be put to sleep, but I'll try to make this interesting. We're going to be talking about Emmett Bolden versus the Keith Theater, which was as a business, the Grand Rapids Operating Company. So that's the name of the case. It's often called Bolden v. Keith Theater. Just in a nutshell, he was African American. He wanted to attend a program one evening and was told the balcony was all sold out then and that he could not buy a ticket. So he sued, and we'll go into that. Here's a picture of Dr. Bolden at about that time, and also a photo of the Keith's Theater, which was on Lyon Street. It's where the Fifth Third Bank building is today. And his decision from the Michigan Supreme Court was in 1927. It struck a blow to enforce segregation in Michigan and for integration. There's the balcony looking up at the balcony, and there's the balcony looking down from the balcony, and we'll go on. By way of introduction, I'm going to give you the civil rights legal history before the Bolden case, and then how the Bolden case came about, and I'll talk to you about the Grand Rapids Superior Court and the Michigan Supreme Court decisions, and the civil rights context in Grand Rapids society in 1927, and what followed from Bolden. First, it's important to note that Grand Rapids and Michigan in particular, has an early and lengthy progressive legal history on civil rights. We'll see that society often followed slowly, but Michigan case law and statutory law was sort of leading the way. In 1867, a Michigan statute prohibited racial segregation in public education. An early case against the Detroit public schools required that they admit African American students. They weren't before that time. In 1867, Michigan legislature prohibited life insurance companies from distinguishing between white and, quote, colored, unquote, persons. In 1883, the Michigan legislature removed a ban on miscegenation. In 1885, the legislature adopted the civil rights statute that comes into question here. And that was amended again in 1919. And when the Bolden case came to the Michigan Supreme Court, it was the amended statute. The Bolden case is hugely important. It is a landmark. But when Dr. Bolden approached the Keith Theater ticket booth, much of the legal foundation for his victory was already there. And we go back for that to 1890, the case of Ferguson v. Gies. In that case, the Michigan Supreme Court rejected separate but equal as a doctrine and allowed, based on the Michigan Civil Rights 1885 law, a civil action for damages for discriminatory seating in a saloon restaurant in Detroit. Here's the amended statute. So this jumps ahead a little bit, but it guaranteed to everyone in the state, quote, full and equal accommodations, advantages, facilities, and privilege of inns, restaurants, eating houses, barber shops, public conveyances on land and water, theaters, motion picture houses, and all other places of public accommodation and amusement and recreation, and all public educational institution. Remember that, because when we get to the Superior Court decision in Grand Rapids on Bolden, you're going to go, well, how did you get around that language? So in 1890, Mr. William Ferguson, shown here as a handsome, dapper fellow, was denied seating for dinner in a Detroit restaurant. He was restricted by the manager, Mr. Gies, to seating in the saloon area. He wanted to sit in the restaurant area. He was in fact told, well, you can sit in the restaurant area around the corner there where no one will see you. So he was unwilling to do that. He sued Mr. Gies and he won in the Michigan Supreme Court. His claim was for civil damages for violation of the 1885 criminal statute. He was represented by Mr. Augustus Straker, a picture of him shown here. Straker successfully argued in the Ferguson case in the Supreme Court, Michigan Supreme Court, that separate but equal was not permissible under the 1885 statute. He was the first African American lawyer to argue before the Michigan Supreme Court. Mr. Ferguson might have had some negative reaction to the court's paternalism in its decision that ruled in his favor. It said, "The law is tender rather than harsh towards all infirmity, and if to be born black is a misfortune, then the law should lessen rather than increase the burden of the black man's life." Unquote. So I'm suspecting that Mr. Ferguson was pleased with the decision in his favor, but might have said, "No thanks, I've got my own bootstraps." So what followed from Ferguson? Virtually nothing. Why? There were no teeth to enforce the statutory prohibition on segregation. If you sued for damages, what would your damages be? We don't know what Mr. Ferguson was ultimately given by way of damages. The case would have been returned to the trial court, and they would have tried the case on damages, and maybe they just gave up. I have no record that I can find as to what happened thereafter. So in 1925, and that's 35 years after the Ferguson case, Mr. William Glenn approached the ticket booth at the Keith Theater. This was, you'll see, in the same year as Bolden came to the Keith Theater, but Glenn got there first, and his attorney was Oliver Green, and he was denied seating except in the balcony, which was sold out. So he filed suit. He went to the Grand Rapids Superior Court. He lost in front of Judge Leonard Verdier there, and he did not appeal. So I'll talk about what came about then when Bolden came. The Bolden case was put together. But Glenn is an interesting fellow. He was an activist and a photographer for much of his life, and he was a Communist Party member. And here's a photo of him many years later. He was welcome to come with a group to the Soviet Union sometime later in his life because they were Communist Party members, and the Soviets always tried to parlay propaganda out of our racial strife in this country. He was given a camera there, and he started taking photos, and then photography became his avocation, and he is a fairly well-known Michigan photographer over the rest of his life. Grand Rapids Superior Court, what was that? Well, here's a photo of Judge Leonard Verdier later in life, and I'm pretty sure that is him seated on the circuit court bench in the old courthouse. He was on the Superior Court of the city of Grand Rapids in the mid-20s, and he decided both the Ferguson case and the Bolden case, and ruled against them and in favor of the theater. There's a photo of the window from the judge's chambers in Superior Court in the old City Hall. My father was the last judge of that court, which was abolished in 1963, and he was then appointed to the bench of the circuit court. They added another circuit judge, and he was appointed to that court. In 1969, before the City Hall was torn down, my older brother, who was a young attorney at the time, went into the City Hall and asked whether he could take that window. If he hadn't done that, it would have gone in the dumpster. So he had it made into a mirror and has had it ever since. The Superior Court, just quickly, Superior Court had jurisdiction over all criminal acts committed within the city of Grand Rapids. Kent County Circuit Court had jurisdiction of all of those happenings outside of the city. Otherwise, they were both the highest trial courts in Kent County, and they had some concurrent jurisdiction. So let's get to Bolden v. Grand Rapids Operating Company. So Bolden's journey began in 1925, the same year as Glenn's earlier lawsuit. Most certainly, Bolden and his attorney Oliver Green, a very noteworthy early black attorney in Grand Rapids, set this up intentionally as another test case. Since the Ferguson case, he chose not to pay to bring it up to the Supreme Court, or Oliver Green just didn't have the time, or whatever. But attorney Oliver Green and client Bolden organized support, including the NAACP in Grand Rapids and other legal horsepower, to take the case up on appeal. There's a picture of Oliver Green and also a picture of Floyd Skinner. Floyd Skinner was in his third year of law school at the University of Michigan. He was a sharp legal mind, and Green went to him and hired him to write at least part of the Supreme Court brief. That's Floyd Skinner later at the microphone in the Club Indigo above the Russo's Grocery on South Division, and he was one of the movers and shakers in putting together Club Indigo, which provided much black entertainment in Grand Rapids. Seated next to him is Sergeant Walter Coe of the Grand Rapids Police Department. So Dr. Bolden and 3 companions approached the ticket booth to attend a photoplay and vaudeville show. They were turned away because the balcony for, quote, coloreds, unquote, was sold out. They requested and were refused main floor seating. A white man in line offered to buy them tickets, but the ticket seller asked whether he was buying for the Bolden party. He admitted that he was, so he too was refused. My suspicion is that he was in on it, and he was there to help nail down the evidence of the discrimination. So now the facts were there. Dr. Bolden was aggrieved, and he had a case in controversy. That's very important in the law, because a court cannot take a concept up. It has to take a case where someone has been aggrieved by something and has something to sue for. Dr. Bolden was denied entry to the theater because of his color of skin, and he was aggrieved, and he had a case in controversy. The program that they were attending that night included a photo play, as they were called at the time. It's a silent movie. It was Jackie Coogan in the movie Old Clothes. I find nothing about black or white inherent in that film, and that's kind of important, because the other part of the show shown here on the newspaper ad for it included several vaudeville acts, and I have looked them up, and I don't find any offensive, like no minstrel show stuff in there. Although minstrel shows, as you're going to see, still came to the Keith Theater in the mid-20s. But the closest I could find was this Elkins, Fay, and Elkins. They're shown in vaudeville history as a minstrel satire. I don't know what that is, but I couldn't find any photos of them appearing in blackface. So I'm thinking that Bolden, when he and his companions set this thing up, they might have chosen a program that they thought would be well attended by African Americans, so that the balcony would be filled when they approached, probably late and close to the showtime, so that they could be denied entrance. Now, let's talk for a moment about the defense table, because that's interesting. At the defense table, of course, were the Keith Theater and its manager, Walter Norris. The interesting thing about Norris is that he managed the Keith and some other Keith circuit theaters, and in the late 20s or early 30s, he left to go to Detroit for a job, and he was there for a time, but in the early 30s, he returned to Grand Rapids and was hired to manage the Butterfield theaters, particularly its flagship, the Majestic Theater, now the Civic Theater downtown. And the law firm at the defense table representing Keith Theater was Butterfield, Keeney, and Amberg. So there are some interesting loose threads here for some of you local history buffs to pursue. Amberg was Julius Amberg. He was fairly new to that firm at the time, fairly young, and he had quite a great career in Grand Rapids as a lawyer over the years, and had quite a liberal bent to his representation of things and the causes that he pursued. In the about 1950, he was one of those people who organized the Citizens Council for Good Government, and they held a big rally downtown, and I think he was on the stage along with Duncan Littlefair and an attorney's wife from Mrs. Judd. And they were trying to bring down the McKay machine and its remnants of corruption in City Hall. And they were fairly successful. Julius Amberg grew up in the Amberg House on Lion Street, built by his father. And that's a fairly famous house for architecturally. So, the Butterfield theaters, Walter Norris came and managed them, and I have been told by somebody some years ago that when the Civic Theater was renovating the Majestic, in a back room somewhere, they found a sign indicating that the balcony was for coloreds only. So let's talk about the judgment of the Grand Rapids Superior Court. That was rendered by Judge Leonard Verdier. He interpreted the 1885-1919 Michigan Civil Rights Act as having no application to privately owned business. He concluded that despite the language of the statute, private businesses could exclude anyone they wanted for any reason. He must have felt some comfort and cover in 1925 from the U.S. Supreme Court 1896 decision in Plessy versus Ferguson, the fairly infamous decision over time that said separate but equal was permissible under the U.S. Constitution. Judge Verdier later went to the Kent County Circuit Court, as I think I mentioned before, and he retired from there in 1959. So let's look at the Michigan Supreme Court decision in Bolden. It was rendered June 1927. Justice Nelson Sharp wrote the opinion of the court. There were no dissents, but 2 justices did not sit on the case, and I suspected they chose to sit it out and not express an opinion for whatever reason. Made 2 important holdings. First, the statute applies to privately owned businesses, so that it forbade discrimination by the theater and by any other public accommodations. Second, though it was a criminal statute, it did provide Bolden a foundation for a private cause of action for damages. I didn't put on here, they also found that the statute was constitutional under the Michigan Constitution. They looked at the Ferguson case and they discussed it in their opinion, and they said there was no ruling on constitutionality of the statute in the earlier Ferguson case, but they commented, although the defense must have thought of it, but it didn't come up and it wasn't decided. It was now decided in Bolden that separate but equal is not permissible under the Michigan statute. A person aggrieved by violation of the statute could sue for civil damages, and it does, and it is constitutional. That statute is constitutional. So let's look at the recognition of the Bolden decision's importance over the years. After the Bolden case was decided, not much happened again. As we well know, African Americans who would arrive at a public accommodation in Grand Rapids were often told, no, we don't have any room for you, or whatever. That's why the Green Book was still necessary for African American travelers. But in 1995, the Michigan State Bar woke up to the importance of the Bolden decision, and in their, quote, legal milestone program, they had made a bronze plaque and they dedicated it here in Grand Rapids. And there's a picture of the dedication ceremony. That was 1995. The plaque was placed on the exterior wall below the plaza on Lyon Street at the former location of the Keith Theater. There are three problems with the plaque. One, I'd say it's kind of too small. Although I have read in MLive, some reporters some years ago walking by it, noticing it, learning for the first time of the Bolden case and writing an article about it. So I think it's kind of too small. It might overstate also that it ended Jim Crow. But the next big problem with it now is it's gone. There's the streetscape today, the old Kent, the Fifth Third building. And some years back, not too long ago, it was purchased by a new owner. The Fifth Third is still in there, but the new owner took out the wall there where the plaque was located and put the new stairs down to the lower level and the new stairs up to the plaza. And the plaque has disappeared. So what changed after Bolden? Not very much. And I think part of you have to understand some of the societal context in Grand Rapids in the mid-20s. It included the July 4, 1925 massive march of the KKK in Grand Rapids. And I think that was on the west side. That portion of the march was on the west side. They purposely marched in Catholic neighborhoods because they were as much anti-Catholic as they were anti-black. The other thing is, in 1926, this guy, here's a photo, and there's an early poster of him, Emmett Miller, who was a minstrel man, appeared at the Keith Theater in the Dan Fitch Memories of Minstrels. So minstrel shows as a large touring theater group had died out around the turn of the century, but the smaller minstrel shows continued and were in vaudeville as one of the acts in vaudeville. And this guy, Emmett Miller, who did some very good recordings, early jazz recordings with him singing, but he appeared at the Keith in 1926. Grand Rapids Theater Reviews at the time called him, one, said he was very funny, and two, he was a great clarinet-voiced hot singer. Now, hot singer meant he sang jazz. So so as you can see, society wasn't too much in tune with the Bolden decision at the time, nor were they thereafter for some time. Just a little anecdote there. I went to the theater in the mid-50s with my dad and my older brother. I can't remember what movie we saw. I can't remember what theater we went to. It was in Grand Rapids. The theater had a balcony, so it was probably the Keith or the Regent or the Majestic. And I asked my dad going in, can we sit in the balcony? And he said, no. And I said, why not? He said, because that's where the colored people sit. So now as we come into the 1950s, much of the legal foundation, let me emphasize that, for equality was in place in Michigan, but largely unenforced. Then came the beginnings of the civil rights movement of the 1950s. First, there was the 1954 decision in Brown versus Board of Education. Chief Justice Earl Warren wrote the opinion of the court with no dissents, and it said Plessy versus Ferguson was wrong. Separate but equal is never equal. It is unconstitutional discrimination. So it's surely settled the question for education at the time, but it had broadly held separate but equal doesn't work, and it was never equal. The interesting thing about the Chief Justice and that decision is he twisted arms of the other justices to write no dissents, no other word, no concurring opinions, but stating anything else. He said this has to be a majority opinion, not a majority opinion. It has to be a unanimous opinion, or people will not accept it. Now, in August 1955, the nation saw Emmett Till murdered. We cannot underestimate what that said to the country, and we know it from the current movie Till, how the public saw that. And in a little while later, Rosa Parks refused to give up her seat on the bus in Birmingham, and we have that nice bronze statue of her downtown here at Rosa Parks Circle. And that triggered the Birmingham bus boycott, and those three things together, I think, are the most important things, and including Dr. King then leading the way on the civil rights movement. So the thing we need to see in all of this is that sometimes, not always, but sometimes the law leads, and then hearts and minds are reluctantly dragged along. That's what's happened here. Here's what Lincoln said. He said in the Lincoln-Douglas debates, which were generally about slavery and the extension of slavery or non-extension of slavery into the territories, he said, public sentiment is everything. With public sentiment, nothing can fail. Without it, nothing can succeed. So his opinion was political persuasion depends on having the support of public sentiment. But it's pretty clear that Lincoln had a heavy, heavy lift to persuade public opinion to be on his side, to amend the Constitution in the blood of the Civil War, 800,000 plus lives being lost to do that. Make no mistake, the Constitution of the United States before the Civil War permitted slavery. Slavery was fought ultimately to put an end to slavery, and after that the amended Constitution made that a certainty. So Dr. King, Rosa Parks, Emmett Till, the March on Washington created more and more public sentiment that ended up putting Michigan law, Ferguson and Bolden, into practice. Dr. King paraphrased an 1840s abolitionist pastor's sermon when he said that the arc of the moral universe is long, but it bends toward justice. He was asked how long. He said, how long? Not long, because truth crushed to earth will rise again. The Bolden case is now in front of us. It's now immortalized, and it now tells us what the law was then and must be as enforced now. So I'm going to end just showing you this t-shirt. I saw it first at an art gallery in Tucson last year, and it really hit me. Eracism, a noun, the removal from existence of the belief that one race is superior to another. I'll just leave you with that. You can order the t-shirts online if you're interested. Thank you very much, and have a good day.